possible to end their service when we do not do.
Thank you.
Because according to their submission on the obligation of the no-harm principle, it is the obligation of the state to ensure that the actions within their state do not affect the states. It's not the obligation of the corporation, the obligation of the state. So, what did you do in terms of your contract so that you can see you do not have control over the corporation? What steps can you see?
Thank you, Your Honor, for your question. And in setting the no harm principle, we submit that these principles apply to obligations by state to other states. We submit that the acts that happened here, the transboundary harm, was not caused by Malindi as a state. Therefore, Malindi cannot be held liable. Therefore, the no harm principles cannot apply in this case. Furthermore, Your Honors, as per the last test for effective control, the state must be involved in planning, supporting, or helping them in executing their actions. Your Honors, since they have corporate autonomy, we lack a sufficient degree of control to plan on their behalf with regards to their operations. We therefore submit that Malindi cannot be held liable in that regard. Your Honors, if that suffices the nature of our submissions as the respondents, and having come to the end of my submissions, the respondents wish to state their prayers.
Council, we request you further prayers because of time. I'll let the petitioners have their 2 minutes.
Much obliged, Your Honor. I see the floor back to the bench.
You have 2 minutes. The baby, if you can start counting the time because
Greetings, honorable members of the bench. My name, as previously introduced myself, is Austin Mama Murithi, and I am the lead counsel here to give our points of rebuttal. On our first point of rebuttal, we reiterate the case of Republic versus IEBC and 6 others in 2017 for the High Court, where it was held that the exhaustion doctrine is particularly accepted, it is particularly exempted from matters which involve a constitutional value. Counsel for the respondents, the first counsel for the respondents, tried to reiterate that the greenhouse gas emissions as well as environmental social impact assessment is not part of the environment rights. It is our submission that the environment and social impact assessment required public participation, and this public participation was with regards to how the land was supposed to be used. As well, greenhouse gas emissions affect the environment, hence the right to a clean and healthy environment as enshrined in Article 42 of the Constitution is the value that is at stake, hence this particular case is not subject to the exhaustion doctrine. On our second point of rebuttal, the second counsel for the respondents tried to recuse himself from causation. It is our submission that indeed Talmud Limited is held liable for the greenhouse gas emissions as well as the environmental disasters. We attribute this causation pursuant to Section 7 of the Evidence Act, which provides that where a person, where an event, where there is an occasion for an event, or where it affords the state of something to happen, pursuant to cause and effects. Facts which afford for the state of something to happen are relevant facts, and we submit the following relevant facts which attribute causation to Talmud Limited. According to paragraph 22 of the compromise, we see that Kiwani Conservation Group submitted that there were complaints for greenhouse gas emissions. We do not see Talmud Limited mitigating these measures, and as a result, we see in paragraph 25 that there was experienced a deluge that has not been seen in decades, and hence we attribute possession of this deluge, these floods, to the greenhouse gas emissions of the respondents. On our last point of rebuttal, we rely on Article 23 of the Article 23.2 of the DARCIWA, which is the draft articles on responsibility of states for internationally wrongful acts, which states that it does not apply, force majeure does not apply in the event where it was contributed by a state. In this case, we submitted that it was anthropogenic, which means that it included human intervention. In this case, it included human intervention, hence it is exempted. The state is exempted from denying liability, it is exempted from denying foreseeability, hence it should be held liable under Article 23.2 of the DARCIWA principles. With that, I cede the floor back to the bench for further directions.
So the bench has noted your submissions, counsel. Because of time, I will request that you have the next round in about 5 minutes. That is 5:20 if possible. There is no scouting, so maybe we can give the comments later.
Just
Let the other team.
considering tomorrow is directly knockouts, you can just give them some very important comments they need to note as we also take photos. So just some very important comments.
The other team can.
They are here, they are prepared. So you can just give some important comments for knockouts. So that as they proceed to knockouts, they know what they are getting themselves into. So just for 5 minutes, that is okay.
So we can begin with
Yes, thank you.
my
Okay, good afternoon. I'll just proceed to giving my comments. Well, for Austin, I like your arguments, your command of the law. You're generally good. What I'll urge is that you don't let questions throw you off. Also the same for Samba. For Felicity, well, I don't have comments. She's good. Also Cyrus. Cyrus, be more persuasive with your arguments.
Give comments to everyone. Felicities, yes, we acknowledge she's good, but give comments. She might not make it to the final, so give comments. Yes. Just to show impartiality.
Okay, I'll let my co-judges give comments when I think of a comment to give.
Hi. Okay, so I had a great session. For Austin, as my father just said, just work on your composure, especially in questions. Samba, your arguments are good. Thank you, Austin. So for the petitioners, your composure and build more on your arguments, especially on the ELC Act and the Liquor Act. Be more conversant with them. For Ferry, your arguments are good. You have good responses to questions. I think what you should also look on is on the fourth issue of public participation. Please we look more into it. And for Cyrus, be more persuasive, especially on the matters to do with liturgy. But for this negligence, can you look into that? Yeah, that's all for me.
Duncan.
I'll only give general comments. And my concern is authorities. I have a very big concern on the citation of authorities because I basically note the amount of cases you can cite properly, not just citing. The articles you are citing, and remember it's a petition. So for petition, I'm expecting that you are talking about specific contraventions, either of a right or an international provisions. Because I always say this, you can see our law reporting, the EKR, we have, you look at constitutional petitions, it says concerning Article 40, 43, and 44 of the Constitution, or concerning in contravention of Article 3, 4, 5 of the Convention on Biodiversity. So I'm expecting, can you be very specific, and you should note the things that you have to insist on. There are things you don't have to insist on, there are things that build up your case. So if you are talking about a specific contravention, it's the public participation. Can you please, first of all, start from a point of where that provision is on public participation for the process, and which process is it? Because if you're not specific on your submission, then I cannot trace the specific contravention in your application. And that is a challenge when I'm giving marks for legal arguments. And for answering questions, there are two types of questions. There is a factual question and a legal question. So can you note, if I'm asking a factual question, can you just give a factual answer? For a legal question, give a legal answer. That is how simple it's supposed to be. So I guess that should be it. I hope to see you in the knockout.
Okay. I wish both teams the best of luck tomorrow. The knockout shall start at exactly 8:30. And yes, if you find yourself going against a good team, don't worry, it is given. If you find yourself going against a bad team, far away. Otherwise, we shall welcome the second team, and we shall start at exactly 5:30. If that is okay, that is the way that was sorted. Yes, we shall start at exactly 5:30. Yes. So we shall give way to the other voters for this is our photo session. Yeah. Yes. Even the bailiff will be sorted. Yes.
There is no scouting, so I'm expecting that this thing is
Yes, there is no scouting. But however, for the audience, if you want to take notes of legal arguments and help your teams, please help them. Take notes, Africa, and then so that when it comes to the knockouts, we know who is representing us on Monday. Yes. So beautiful. Austin, you look very nice.
Just go there.
You look very nice. Okay, shall we welcome the second team? The second team. Yes. Also, somebody look very nice. Wait, the second team. Wait. The second team. Yes. You are the second team. Yes, we are live. Tafadhali, we are live. Tafadhali, the YouTube is live. The YouTube is live. Tafadhali, tuingie. Time is of the essence. Tuingie tafadhali. As you can see, the YouTube is live. Tafadhali tuingie. Tafadhali. Hugs will be after you reach the finals. Tafadhali. Hugs itakuwa after finals. Right now, your enemies. Hello. Is that not okay? So this is nice. We are going to start at 5:30. let me get the beverages for the other. Let me get the ones for the judges. And we use this. Yes, they are impress that
Mercy survives. Mercy survives. Oh, no, successful.
All right. The Republic of Manini in the Environmental and Land Court at Nairobi Petition number 8 of 2024 between Kasiri Community Organization and two others versus the Attorney General and two others.
So good afternoon. My name is Mashira Duncan. I'll be the presiding judge for purposes of this session. I'll let my co-judges introduce themselves from my right.
Good afternoon, good evening. My name is Darina Chingatai. I'll be co-judging this session. Good luck to all the teams.
Good evening. My name is Amani Andika, and I will be co-judge, and I look forward to listening to your submissions.
So let us begin in like 2 minutes, but meanwhile, let us have the team codes for this team and your team. So your team is team 30. Team 20. 20. So all the teams have 20 minutes. For the petitioners, we will give them 2 minutes for rebuttal, extra 2 minutes for rebuttal. So I am told you already moved on. So time starts counting when you have introduced yourself and your teammates, and the bailiff will post time when we are asking questions. So whenever you are ready, counsel for the petitioner, you can begin. Unless you have any clarification.
Have you already decided on who is going to be the petitioner?
Unless you have any clarification. Counsel for the petition.
Greetings, honorable members of the bench, may it please the court. My name is Mwaki Elizabeth Wangeshi, lead counsel appearing on behalf of the plaintiffs. With me is my co-counsel Sylvester Daniel. We will use 20 minutes of this honorable court's time as follows. I, as lead counsel, will use 9 minutes on issues A and B, where on issue A, it is our averment that this court has jurisdiction to hear this matter, that the plaintiffs have local standing to appear before this honorable court, and that this case is admissible before this honorable court. I will use 5 minutes to discuss issues B, where it is our averment that Salmour Limited should be held liable for its contribution to greenhouse gas emissions and environmental disasters. My co-counsel will use 10 minutes to discuss issue C, where it is our averment that the Republic of Malindi bears responsibility under international law for the transboundary environmental harm caused to Samira, and issue D, where it is our averment that the environmental and social impact assessment process was flawed and violated the constitutional right to public participation. We shall reserve 2 minutes for rebuttal unless the court directs otherwise. I wish to proceed.
Counsel, what happened to the advocate at time? You were before the court. You are aware of the advocate address. So, what excuse does counsel have?
There was a tiny wardrobe malfunction today, so I have to attend this.
Proceed.
Honorable members of the bench, on the issue of jurisdiction, local standard, and admissibility, it is our submission that this honorable court has jurisdiction, the plaintiffs have local standard, and that this case is admissible before this court. On the issue of jurisdiction, Section 13(2) of the Environment and Land Court Act bestows upon this honorable court appellate's and original jurisdiction to hear, in accordance with Article 162B of the Constitution, to hear cases involving alleged violations of environment and land rights. The Constitution of Malindi upholds environmental protection as a fundamental right, and the issues raised in this matter touch on the obligations of the state and private corporations to mitigate environmental impacts and protect community welfare, placing this case within this honorable court's purview. It is our submission that the parties have local standing to appear before this honorable court. In Black's Law Dictionary, local standing is described as the right to bring action or the right to be heard in a particular proceeding. In the case of Alfred Njau and others versus the City Council of Nairobi in the Court of Appeal, the court held that the term local standing means a right to appear in court, and to say that a person lacks local standing means that they have no right to appear or to be heard in a particular proceeding. The plaintiffs have standing to bring this petition as representatives of the affected people of the community of Kasiri. Malindi's constitution broadly recognizes the rights of individuals and organizations to initiate public interest litigation pursuant to Article 22 and Article 258 of Malindi's constitution. A person must have sufficiency of interest to sustain his standing to sue in a court of law. This was the holding in the case of B.V. Narayana Reddy versus the state of Karnataka Air. The environmental organizations and community groups such as the Kasiri Community Organization can therefore litigate on behalf of the broader community, arguing that the government and Talmud's limited actions have infringed upon the community's constitutional rights to safe and healthy environments protected by Article 42 of the Constitution. The matters herein are within this court's jurisdiction, hence are consequently admissible. The plaintiffs assert that this court has jurisdiction to listen to this matter. The plaintiffs have local standard to appear before this honorable court, and that this matter is admissible before this honorable court.
On admissibility, have you exhausted all local remedies before hearing to this court?
Much obliged, my lady. Pardon the question?
Have you exhausted all local remedies? For instance, the National Environmental Tribunal, especially on natural issues D and D.
Much obliged, my lady. The National Environmental Tribunal has limited jurisdiction as it does not have authority to decide matters relating to violations of land and environment rights. Therefore, this court is in a better position to listen to this matter as it pertains issues of environmental land rights violations. Also, this court has original jurisdiction to listen to cases involving alleged violations of environment and land rights.
Counsel, have you said that the National Environmental Tribunal does not have jurisdiction to hear environmental matters?
It has limited jurisdiction in that it can listen to disputes regarding the environmental social impact assessment process and cases relating to enforcement of environmental law. So this court is in a better position to listen to this matter.
So, counsel, from your own words, the tribunal has jurisdiction to hear matters concerning environmental social impact. So you are admitting that you did not exhaust your remedies with regards to the fourth issue that concerns the same.
This much obliged.
So we should only have 3 issues before that.
This was a matter of urgency since it deals with violation of human rights that are protected under the Constitution of Kenya. And there are exceptions when it comes to exhaustion of local remedies, and we think that and we assert that this matter was an urgent matter that needed to be dealt with.
What are the exceptions?
Urgency, complexity, and issues like international law.
Do you have an authority to support your point?
I would like to be guided by this honorable court.
Again, paragraph, if you have the compromise, the fact sheet review, paragraph 14 of the fact, and specifically the last line, that in case of a complaint by the people affected by the project funded by World Bank, the financial institution had established an independent accountability mechanism that would receive those complaints and begin investigating towards dispute resolution. So that was another avenue that concerns the whole dispute that it did not go to. And again, on your submission that this issue concerns human rights, why didn't you go to the High Court instead? Because my reading of the last issue concerns public participation that is provided for in a variety of articles in the Constitution, but more notably in Article 70 Article 69 and Article 10 of the Constitution. So don't you think the High Court would have been a better target for that issue concerning council participation?
Much obliged. My co-counsel is dealing with issue D and is in a better position to respond to your question. However, on the question that you posed to me first, non-governmental organizations such as the Kiseweni Conservation Group in paragraph 24 of the compromise issued warnings that the factory's operation had negative impact on the environment. And when these complaints were lodged, the government did nothing to address these complaints. Therefore, we the petitioners thought it was better to move to this court for redress. With the permission of the court, I would like to proceed to issue B, where it is our averments that Talmud Limited should be held liable for its contribution to greenhouse gas emissions and environmental disasters, particularly with regard to floods, landslides, and health impact on the community. Talmud Limited could be held liable under multiple doctrines, and we will use two limbs of arguments to support our claims. Our first limb of argument is that Talmud Limited should be held liable because of a clear breach of obligations under the environmental social impact assessment and the duty of care owed to the people of Brazil. The duty of care is a fundamental principle in tort law that required Talmud Limited to take the reasonable precautions to prevent foreseeable harm to the people and to the environment. In paragraph 16 of the compromise, we see that Professor Bakari's assessment explicitly noted that the geological conditions in Mirenga Valley, where the project was situated, were prone to instability, potentially leading to ecosystem collapse and landslide. Despite these warnings, Talmud Limited proceeded without implementing the necessary risk mitigation measures that a responsible corporation would have undertaken. Talmud Limited disregard for potential risk suggests negligence as it failed to address the critical issues that were outlined in the environmental social impact report.
Council, what are some of the precautionary measures you would recommend the government to have taken?
Much obliged. Some of the precautionary measures would have been properly assessing this land and probably stopping mining operations as this area is a soft ground, is classified as a soft ground area. By continuing with this mining operations,
Council, so is it your submission that when a country has minerals that are in a soft ground area, it should abandon those things? Because you are saying that they should have done away with mining activities in such a way. So does it mean now we stay as if we don't have minerals?
Much obliged, Your Excellency. It is not to say that mining activity should stop. However, time should have been taken to properly assess the land and come up with measures that would prevent such risks.
That is exactly my audience question. What are those other measures now? You are saying that should have been taken into account.
Consultation with experts to see other alternative methods and safer methods of mining. Our second limb of argument is that Talmud Limited is liable for greenhouse gas emissions and climate vulnerability together with negative health impacts. The Kasiri Cement project, operated by Talmud Limited, is a major source of greenhouse gas emissions, heightening the local community's exposure to climate risks like floods and landslides. The project's concentrated emissions contradicts Malingi's obligation under the Paris Agreement, specifically Article 4, of the Paris Agreement, which requires emissions reduction efforts aligned with the nationally determined contributions. Talmud's limited lack of emission control and failure to adapt to its operations to climate commitment escalated climate vulnerability in Kasiri, making the company potentially liable for the risk. Talmud Limited neglected its obligations under Section 15 of the Climate Change Act, which mandates corporations to reduce emissions. In the case of Agenda Foundation versus the State of Netherlands, the Dutch government was held liable for failing to reduce greenhouse gas emissions Similarly, Talmud Limited could face liability for endangering the Kasiri community through its environmental impact.
Just for want of trying to answer, how, or what amount of contributions are we talking about?
Talmud Limited contributes 0.1% of the total greenhouse gas emissions.
Is that is the country according to paragraph? According to paragraph 5, that is the country, Mayundi as a country. So is that within the purviews of the Paris Agreement or beyond the contribution that is required? 0.1%. It almost seems negligible contribution.
Much obliged, Your Excellency. In as much as this contribution is minimal, it still affects climate vulnerability, and to neglect it would be wrong, as these emissions still affect the climate.
But you know that contribution was before, because in paragraph 22, we are told that Kasiri Cement project was able to remove and store 10,000 tons of carbon dioxide, with which the sale of carbon credits resulted in revenues invested. So, is this removal and storage of CO2 what you are saying that contributed to the climate change?
Pardon?
Because they removed the CO2 and stored it. So is it released to the environment, or how is it contributing to climate change? Paragraph 22.
In paragraph 24, the factory's operations were contributing to greenhouse gas emissions, thereby worsening the climate change within the region and increasing the region's vulnerability to extreme weather conditions. So Malindi is still contributing to the greenhouse gas emissions, and according to the Paris Agreement, they should take all measures necessary to reduce their emissions.
You know, my concern is, can we point to the specific contribution we are making? Because the one we are told, the specific contribution we are told it's stored. So if they say there is no contribution, there is no specific contribution that is there to show they are contributing to climate change.
However, Your Excellency, however, my Lord, the cement factory located in Kasiri still contributes to greenhouse gas emissions.
No, the concern is it is agreeable that there will always be greenhouse gas emissions. They're supposed to reduce the emission. So you are supposed to tell us the percentage that they are contributing is way beyond the margin that is there. Because we are not told that there is any way we have zero contribution to greenhouse gas emissions. So at any given point, there is greenhouse gas emissions. So what matters is the amount that is being emitted in the amount of contribution that that company is having. So if you cannot point us to the specific contribution that Moot is having, then how are we going to hold them liable?
Much obliged, Your Excellency. I would like to seek guidance from this court.
Address us on that issue concerns three issues. One is the floods and landslides. The other one is the health impact on the community. So we are told that before the water was clear. Now it's milky and has lime poisoning. Is there any way you can attribute that to the lime poisoning?
Much obliged, my lord.
You have a discussion, that's it.
Much obliged. Talmud Limited is responsible for polluting local water resources with lime deposits, causing illnesses in children and death of livestock. This is in paragraph 23 of the fact sheet. This pollution breaches environmental health standards and violates the public trust doctrine, which mandates that certain resources, such as water resources, are preserved for public welfare. The case of MC Meta versus Kamala supports this as it upholds the public trust doctrine, suggesting that Talmud Limited is accountable for harming shared water resources. The Water Act 2016 of Malindi guarantees every individual's right to safe and clean water. Section 63 and 143 of the same Act prohibit unauthorized pollution or interference with water resources, reinforcing Talmud's liability for environmental and health damages. In light of our submissions, the plaintiffs pray that this court finds Talmud Limited liable for greenhouse gas emissions and environmental disasters.
So which relief do you seek on those two issues? The relief pursuant to Article 23 of the Constitution.
Pardon?
Which specific relief do you seek pursuant to Article 23 of the Constitution?
Much obliged. We seek that Talmud Limited and the government of Malindi be held liable for greenhouse gas emissions and environmental disasters.
Just a guidance. There is a difference between the remedies and the relief. Relief is listed in Article 23 of the Constitution, as well as the Environment and Land Court Act. The specific relief the court cannot. And among them is a declaration of right, an injunction, conservatory orders, a declaration of invalidity of any law. So you should look into that so that when you ask for a remedy, it's what the prayers you have, but the relief has to be specific. We can have counsel for the second counsel.
Greetings, honorable members of the bench. May it please this court, as earlier introduced by the lead counsel. My name is Sylvester Daniel, the second counsel appearing on behalf of the plaintiff. We intend to take 10 minutes of this generous time adduced to us by this honorable court to tackle on issue C and to tackle on issue D. On issue C, it is our government that the Republic of Malindi be held liable under the international law for the transboundary harm caused to the state of Samira. And on issue D, it is our government that the environmental social impact assessment was duly flawed and violated the constitutional right to public participation. My lord, my ladies, I'll proceed to submit on issue C. On issue C, we will argue on two limbs of argument. First, on the principle of transboundary responsibility, and second, on the principle of the no harm, on the principle of no harm. My lord, my lady, the principle of transboundary responsibility, I will rely on the Rio Declaration principle of 1992, principle 2, which states that states shall prevent transboundary damage, bearing in mind that they have sovereign sovereign authority to exploit their own resources. According to the 1996 legal opinion on the legality of the threat or rather use of nuclear weapons, the International Court of Justice recognized the general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states. And therefore, this part of the corpus was included into international law to laws relating environment. My lord, my lady, if you can move with us to paragraph 26 of the compromise. I read in verbatim. To the east of Malindi, bordering the village, the Mirena village, the neighboring country of Samira was also severely affected by the dilute flooding. As the floodwaters from Malindi flowed southeast towards the Azov Ocean, the riverbanks block flooding the neighboring communities in Samira. Therefore, it is very evident that the state of Samira, which borders the Republic of Malindi to the east, was adversely affected by the floods which were caused due to the activities of the Republic of Malindi in the Kasiri cement project that led to also the contamination of waters. My lord, my lady, on the second limb of argument, which is the no harm principle, I will rely on the maxim which says that sic uterum tuo at alienam non ledam, which means that you can use your property in as much that you will not cause injury to others. My lord, my lady, relying on the trial smelter case between USA and Canada, where the tribunal found liability to Canada after causing transboundary harm to USA and went further to state that Canada should compensate USA. My lord, my lady, it is very evident that the damage was done to the state of Samira and this damage is already there. So therefore, it is a submission that the damage was real. My lord, my lady, on the ICJ's judgment in Gabsikovo Nagimaras between Hungary and Slovakia, the ICJ highlighted the duty of states to consult and cooperate to prevent environmental harm. It is evident that the Republic of Malindi took no step to discuss with the other neighbors on the risk associated with the project that they were going to do. And that is also stated, the risk are stated under paragraph 16 of the compromise. So therefore, in light of our submission on issue C, it is our prayer that the Republic of Malindi should be held liable for the transboundary harm caused to the state of Samira. Therefore, I would like to...
Before you proceed to the next issue, just a clarification. How are those principles, international principles, applicable to the Republic of Malindi?
My lord, much obliged. Article 2 of the Constitution of Malindi imposes that international laws should form part of the laws of the country, my lord.
Which specific clause are you talking about? Article 2 clause.
My lord, very much obliged. I would like to seek the indulgence of the bench. I'll proceed to issue D and our last issue. It is our submission that the environmental social impact assessment was inadequate, public participation insufficient, and the review of the assessment report inadequate. And therefore, the environmental and social impact assessment was flawed and violated the constitutional right to public participation.
So on that issue, I request you address these three issues. One, classify the project. What type of project is it? Because not all projects require the environment social impact assessment. It's a project that is in the second schedule of the MCA. So what classification of this project, this binding project of life, what classification is it given under the second schedule of the MCA? Then, if after classifying that, tell us what is the process that should be taken. You are saying that the process was followed. Then what is the process that should have been followed? And again, the last thing, what the requirements of public participation when conducting environment social impact assessment. Under the 16th regulation 17 of the environment regulations of 203, the specific provisions of public participation, and which one was breached?
Much obliged, my lord. I'll be tackling on those issues on my submission. My lord, on the first limb of argument, I will discuss how the environmental social impact assessment was flawed, and on our second limb of argument, I will clarify on the insufficiency of the public participation. My lord, my lady, on our first limb, the procedure to perform environmental social impact assessment is well outlined in the environmental impact assessment and audit regulation under section 11 to section 17. The procedure should be as follows. I'll read the verbatim. Preparation of terms of reference for environmental social impact assessment by project proponent and approval by the authority, approval of experts, registration of environmental impact assessment experts, preparation of the environmental social impact assessment study, public participation, submission of the report to the authority, and then finally, the authority shall take keen scrutinization to the report and submit their declaration within 3 months. My lord, my lady, it is a submission that although they follow the environmental social impact assessment procedure, they ignore the associated risk and then the National Environmental Management Authority went ahead to give a green light for the commencement of the project to Talmud Limited before subjecting the report to strategic environmental assessment contrary to section 57A of the Environmental Management Authority. It is also our submission that the respondent issued an AIA license despite the fact that the environmental social impact assessment process had failed to meet the threshold set out for public participation under the regulation section 17 subsection 2 of the regulation. And according to paragraph 17, if my lord, you can move with us to paragraph 17.
The same regulation provides for what the respondents actually have done as per paragraph 19 of the fact sheet, if you may not be clear. It states that to maximize our reach within these limits, we developed a multi-channel communication approach, including local radio broadcasts, public announcements, and collaborations with community leaders. Is it sufficient public participation?
Much obliged, my lordship. I would like to answer your question on the second limb of my argument. On paragraph 17 of the compromise, read in poverty. As part of the SGR requirement, Professor Bakari and her team were required to conduct a comprehensive public participation campaign. This campaign was supposed to gather community views on the proposed Kasiri cement project before its commencement. According to campaign and regional layout, which was intended to lead the expert team in contacting all community members, Professor Bakari's team needed to engage with more than half of the impacted population. My Lord, on our second limb of argument, that is on insufficiency of public participation, it is our submission that while it was true that some sort of consultancy was carried out by Professor Bakari and his team, as alluded, the public participation carried out on the environmental social impact assessment was not effective. It fell short of the constitutional and statutory requirements. Relying on the case of Mugo and 14 others versus Matiani and another 2022, in the High Court in Chuka, the court held that public participation was the centerpiece of every decision made by the state agencies and even non-state agencies. My Lord, my lady, the Constitution required that every decision, whether administrative, regulatory, or statutory, insofar as it affected the lives of the people, had to have the key component of public participation. My Lord, my lady, giving people the right to participate in decision making on matters affecting them not only inspires confidence but also makes them feel respected. And this is what was stipulated under Article 28 of the Constitution of the Republic of Malindi, which states that every person has a right to dignity and the right to have that dignity respected and protected. Seeing my time is far spent, I'd like to ask for discretionary 3 minutes to conclude.
We only issue 2 minutes, but I have a question. You can answer that when you can receive the floor. So for environment, impact assessment and audit regulations, specifically regulation 17 on public participation, which specific regulation or which specific provision of that regulation 17 are you saying was not done? Because you have used paragraph 17 of the fact that says it should meet 50% of the people. That is what the fact says. But is there any legal requirement that you must meet 50+ percent?
Much obliged, my Lord, and I would like to answer your question on the set principle of public participation. In the High Court in Malindi, in the case of Mohamed Bahadi and another was the Attorney General, when the test for public participation was set as follows, I read in verbatim. There had to be evidence of inclusivity, that was to say that all stakeholders or those affected had been given an opportunity to express or ventilate their views. Second, the affected people had to be given sufficient notice of the nature of the decision to be made. Last, thirdly, that the engagement had to be meaningful and done in good faith rather than a mere formality. Therefore, it is a submission that the fact that Professor Bakari's team failed to disclose very crucial information to the community on the risk associated with this project, that deprived them of the good faith, and therefore they conducted the public participation as a mere formality. My Lord, in conclusion, the process of environmental social impact assessment was duly flawed and violated the constitutional right to public participation. This is because public participation did not mean that everyone had to give their views on the issue at hand, as to attend such at standard time would be impractical. A public participation had to however, show intentional inclusivity and diversity. A program of public participation could not disregard bona fide major stakeholders. Otherwise, the program would be ineffective and illegal. Those affected by the policy were expected to have a bigger say in the policy. I rely on the case of Okia Mutata versus Kenya Revenue Authority, which stated that people that are affected by decisions of a state organ should have a larger say to the policy. Therefore, having argued my case, I would like to proceed to our prayers. It is our prayers to this honorable court that it finds that it has jurisdiction to hear the case, that the parties have longer standing, and that this case is admissible before the court. It finds that Talmud Limited can be held liable for its contribution to greenhouse gas emission and environmental disasters. And this court finds that the Republic of Malindi was liable under the international law on the transboundary harm caused to the state of Samira. And finally, that this court finds that the process of environmental social impact assessment was duly flawed and it violated the constitutional right to public participation. If this court therefore needs no further clarification, I would like to cede the floor to the bench for further direction.
Thanks for the respondent.
Greetings, honorable members of the bench. My name is Matthew Nyaki, and my co-counsel is Mundi Lachelle. We plead to use the 20 minutes allocated to us to address on the 4 issues presented before this court. Our stand on issue A is that this court has jurisdiction to hear this case. The respondents have local standing, and the case and some of the cases are inadmissible before the courts. On issue 3 and 4, on issue 2, our stand is that no limited cannot be held liable for its contribution to greenhouse gas emissions. On issue 3 and 4, on issue 3, the Republic of Malindi bears no responsibility under international law for the transboundary harm claimed by Samira. On issue 4, the ESI process was conducted appropriately and in compliance with the ESI framework and international standards and respected the constitutional right to public participation. With the permission from the bench, I would like to proceed to my submissions. Team code 20. We wish to spend the first 10 minutes to address the first 2 issues and the rest of the minutes to address issue 3 and 4. With the court's permission, I would like to proceed. It is our stand as the respondents that this court has jurisdiction to hear the case. We have local standing and the case is inadmissible before the court. Beginning with my first line of argument on jurisdiction, we submit that this court has material jurisdiction which is derived from Article 162B of the Constitution, 162(2)B of the Constitution, which states that the Parliament shall establish courts with status of the High Court to hear and determine disputes relating to environmental use and occupation of and title to land. This broad mandate encompasses disputes on land use, natural resources, and environmental protection, giving ELC authority to hear such cases. Also, under Section 13 of the ELC Act 2011, which elaborates this jurisdiction, specifies that it has power to hear and determine disputes relating to environment use and occupation of land. The case at hand falls within the principles of the jurisdiction of this court. We seek to rely on the case of Karisa Chengo and 2 others versus the Republic, a case in 2015. The Supreme Court, whose decision is binding before this court, addressed the jurisdiction of ELC, stating that its jurisdiction was derived from Article 162(2) and empowered under ELC Act. The court clarified that ELC has exclusive jurisdiction in matters related to environment and land, reinforcing its mandate to adjudicate environmental matters. Proceeding to my second limb of argument, the respondents have no cash standing. As the respondents have standing in pursuant to Article 52 of the Malindi Constitution, which grants every accused person with the right to a fair trial, which is elaborated in the same article, Article 52b, that accused person has the right to public trial before the court established under the Constitution. And since ELC was established under the Constitution of Malindi, therefore it has jurisdiction to hear these cases. Therefore, the respondents have standing to appear to access justice according to Article 48, that states that the state shall ensure access to justice for all persons, and if any fee is required, it shall be reasonable and shall not impede access to justice. We seek to rely on the case law of Republic versus Chief Magistrate Courts at Nairobi ex parte Canon and another in the year 2004. The High Court emphasized that all persons have right to fair trial, including right to be heard, to an impartial tribunal, legal representation, and public hearing.
Counsel, my understanding is that you're conceding that this honorable court has jurisdiction over the matters.
Yes.
And are you aware of Section 4 of the Environment and Land Court Act and Section 129 of the EMCA, which provide for an environmental tribunal to hear over environmental matters? In other words, are you okay that all local remedies were not exhausted before this honorable court was approached?
Much obliged, my lord. There were more remedies. The plaintiffs failed to seek more remedies and came directly to this court, in that they could have first sought the environmental tribunal, which is empowered to hear complaints and appeals related to environmental degradation under Section 13 of the Environment Management and Coordination Act. I'll seek to proceed to my third limb of argument, which is admissibility. It is the respondent's position that issue 3 is admissible before this court, and more issues do not meet provisions provided in the doctrine of exhaustion of all remedies. The plaintiffs failed to ask they should have first sought remedy in the environmental tribunal, which has been empowered to hear complaints on environmental degradation. In the case of Kenya Wildlife Service versus Parish L. Kenya in the year 2014, the court emphasized the doctrine before emphasized the importance of approaching all local remedies before seeking indulgence of the court, as it required the petitioners of the case to exhaust all remedies under Wildlife Conservation Act before seeking judicial review.
Also, for want of clarity, so which specific issue are you saying is inadmissible?
Issue 3
is inadmissible.
Yes.
So which tribunals could have been able to solve that issue?
I would like to answer that question in my proceed to my submissions.
Yes.
This case, climate change is an international issue which transcends borders and requires coordinated policies. ELC, being a national court, lacks capacity to handle complex, transboundary issues such as issue 3 comprehensively. We would like as the respondent to rely on the case of Survey Lamu and 5 others versus NEMA and another in the year 2019, where a community-based organization filed a case against NEMA and Amu company challenging the EIA license for coal power plant. The ELC acknowledged that while mandated to environment and land issues, its capacity to handle transboundary matters concerning and including in the inclusion of countries and international obligations often require frameworks involving treaties, cross-border cooperation, and higher courts, other than the ELC, which is national. With the court's permission, I'd like to proceed to the next issue.
So which court should have handled that issue?
Without the intentions to mislead this court, I would like to seek guidance. With the court's permission, I would like to proceed to my next issue. On our next issue, our stand is Kalmar Limited cannot be held liable for its contributions of greenhouse gas emissions. On our first limb of argument, there was effective public participation done. Kalmar Limited cannot be held liable since an EIA assessment was done and public participation done. Before starting its mining operations, necessary approvals were rendered. Under Section 3 of MCA, a report should be forwarded to NEMA, and NEMA should be forwarded to NEMA and public participation done. Under Regulation 17 of EIA, which states, when conducting assessment study, proponents shall consult with the authorities to seek views from persons who may be affected with the project. Under paragraph 17, Kalmar Limited conducted public participation with the assistance of Professor Bakari, with the plan of engaging more than half of the population, of which is achieved as they are able to overlook 53% of the population. Under paragraph 18.
Council, before you proceed, did the government inform its citizens of the potential risks that may come with the project?
Much obliged, my lord. The government addressed the matter. I would like to answer that question in my second limb of argument, which is the balanced approach. Effective public participation was done according to paragraph 17, where Professor Bakari and her team conducted comprehensive public participation campaign. The public participation was conducted in good faith to fulfill reasonable efforts in public engagement as recognized in environmental law principles. Furthermore, a window for at least once a week in 2 consecutive weeks was exceeded to 3 weeks, providing adequate time for public participation. However, we would like to engage the case of Robert N. Gakuru and others versus Governor Kiambu County and 3 others in the year 2014. The court acknowledged the importance of public participation and also recognized that public participation does not mean census, that every individual must participate. I'd like also to proceed to the second limb of argument, which is balancing the economic development and environmental protection.
On what you just said, that yes, we agree with this. Not everyone is supposed to. We are not supposed to reach to everyone. But when the intention is so clear to eliminate all 53% of the people, then can we say they are given an effective chance, a reasonable chance for public participation, the 53%? Yes, the views, not everyone should participate. But when you intentionally eliminate 53% from the public participation, then how effective is that public participation?
Much obliged, my lord. Under the EAI Regulation 17.2, Roman 3, which states that there should be once a week for 2 consecutive weeks. There should be that window for public participation. This is exceeded to 3 weeks. That is number 2. The old EIA Regulation 17 also provides and states that there should be use of multi-channel communication, which is achieved under paragraph 19 of the fact sheet, where there is an extract of the ESIA report at paragraph 76 stated that to maximize our reach within these limits, we developed a multi-channel communication approach, including local radio broadcasts, public announcements, and collaboration with community leaders. Since my time is much spent, I would like to seek the floor to back the bench.
Second comes for the respondent.
Greetings, honorable members of the bench. May it please discuss. As I introduced, my name is Bashar Windi, second counsel for the respondent. I intend to use the 10 minutes of the time allocated to me by these courts to converse on issues C and D and state our prayers. With the leave of these courts, I wish to proceed.
Proceed.
The respondent asserts that the Republic of Malindi bears no responsibility under international law for the transboundary harm claimed by Samira. This issue will be tackled in two limbs of arguments. On to the first limb of arguments, the respondent affirms that the flooding, which affected both Samira and Malindi, was an unforeseeable event linked to climate change, which is a clear case of force majeure. Malindi could not have reasonably predicted the flooding. Persuasively relying on the ruling in the case Wagmi on River Uruguay, the court held that while states have an obligation to prevent transboundary harm, they are not liable for events that are unforeseeable. Additionally, relying on the ruling of the case Hungary vs. Slovakia 1997, the ruling reinforced that a state's responsibility under international law is dependent on the foreseeability of the damage caused. On to the second limb of my arguments.
Counsel,
Yes.
before we proceed to the second limb of argument, I understand that you think that the floods and the landslide were unforeseeable. However, don't you see that the government ignored the social impact and assessment test, which had warned of a potential landslide? Don't you think that if the government adhered to this could have been avoided?
Much obliged, my lord. Referring to the fact sheet, paragraph 25, it clearly states that the flooding was unprecedented and the country has never experienced such flooding in decades. So I don't think they're liable for that.
Council, I'll take you to the next paragraph. Paragraph 26. Yes, we agree, and I said this before. Even from the Bible, yes, floods are an act of God, but God said He will not kill people with floods again after the Noah incident. And in our case, we have the contaminated water from River Mulenga. That is what went and contaminated the through the ocean to the other state. From paragraph 26. Yes, you have the floods, it's an act of God. So if the water from the floods went to the other state without the contamination, you would have no problem with that. But now the water went with the contamination from your state. And the contamination is from the lime poisoning, from the extraction. So how is the state not liable? Yet the actions of the lime mining are in your own state, and the lime deposits are in your own state anyway.
Much obliged, Your Excellency. I wish to answer your question in the next limb of my argument, which is the second limb, where the respondent asserts on shared responsibility between states. The no harm principle indicates that harm must be reasonably attributable between states. In this case, there's no evidence. Evidence does not conclusively link the contamination as well as the flooding solely to Malini's action. Persuasively relying on the case Pulse Mill on the river Uruguay, the case confirmed that shared responsibility exists when multiple factors contribute to environmental harm and multiple states should take responsibility in addressing the issue collaboratively.
So council, what percentage of the liability then are you accepting? If you are saying we have then shared liability, what percentage of the liability are you taking? Taking into consideration that the contamination came from River Mirenga, which is in your own country. So I'm wondering, plus the lime poisoning, lime is only in the country, that Samira has no lime. So the poisoning is clearly from the state. So what percentage are you taking for the liability? And how can you say, or then show us what other contribution did Samira have in the same contamination?
I stand guided. I wish to proceed. On to the next issue, where the respondent submits that the environmental and social impact assessment process was conducted appropriately and in compliance with the legal framework and international standard, as well as respecting the constitutional rights of public participation. This issue will be handled in two limbs of arguments. On to the first argument, the respondent affirms that the environmental and social impact assessment process for the Kasiri Cement project adhere to the legal framework established under the Environmental Management and Coordination Act, which provides that an ESIA process is mandatory for an environmental project.
So
Yes.
that now takes me back to the requirement of this question, of this issue. For environmental social impact assessment, not all projects are required like here and that. It's only projects that are in the second stage of impact. And so what is the classification of this project? Is it a high risk, low risk, or middle risk project? For it to require environment social impact assessment. And then after that, then you can proceed to show us the specific requirements of public participation for that process. Because if it's not among what is in the second schedule, then there was no even requirement of anything to do any environment social impact assessment, let alone the public participation. So what is the classification? Then what is the specific requirement of public participation under the regulations of 203? And how did you meet that? How did you meet this requirement?
Much obliged, Your Excellency. Referring to paragraph 14 of the fact sheets, the environmental and social impact assessment process was a requirement for the World Bank before the commencement of the project.
Now that's a factual requirement, according to the fact. What is the legal requirement? You know, we cannot go by how the facts say. The facts can say oh, you're supposed to do public participation, but if there is no specific provision under law saying that you must do it, even if you don't do it, the facts, you have no legal obligation to do that. So we want to see where that legal obligation emanates from. That's a factual obligation from the fact part. So even if there is no requirement under law to do that, and you did not follow that factual requirement, it's still within the law. There is no requirement. So where is the legal requirement under MCA to do public participation?
Much obliged, Your Excellency. As I stated earlier, the Environmental Management and Coordination Act provides for mandatory environmental assessments and environmental and social impact assessments for projects with significant environmental impacts. In this case, the Kasiri Cement project.
That is exactly what I'm saying. The MCA provides for mandatory requirements for the projects that are listed in the second stage. So if this project is not part of that, you don't have to follow it. So why is this project listed in that, in those provisions? So that you can see, yes, now it falls within the requirement.
Much obliged, Your Excellency. The project has significant environmental impacts. The people.
Is it a high risk, low risk, or middle risk?
I stand guided the bench.
So now proceed to the public participation requirement. Where is that under where is the public participation requirement when conducting environment social impact?
Pardon your question.
Where is that legal requirement or which provision under the MCA or the regulation that requires you must do public participation?
In pursuant to Article 6 of the Hague Convention, which is ratified by Malindi, it emphasizes on the importance of public participation in environmental decision making. The environmental and social impact assessments conducted included attempts at public engagement despite the challenges faced.
On the challenges you've mentioned, I'm quite interested in paragraph 19, where my question specifically is, how do you balance comprehensive outreach and fiscal responsibility?
Pardon your question, again.
How do you balance comprehensive outreach and fiscal responsibility? This is under paragraph 19, the first part.
Much obliged, my lady. According to paragraph 19 of the fact sheet, the environmental and social impact report clearly states that Professor Bakari's team tried their best to maximize the limits by the multi-communication approach, which included a local radio broadcast, public announcements, and even collaboration with community leaders. On to the second argument, the respondent affirms that the Republic of Malindi tried their best to engage as many community members as possible. The use of a representative approach was a practical decision aimed at maximizing the engagement given the constraints faced. Relying on the ruling of the case, Republic plus National Environment Management Authority, and another ex parte Karanja Mutunga, the court noted that public participation must be understood within the relative of the projects, affirming that reasonable efforts are sufficient to meet public participation requirements. The mixed reactions from the community, with some individuals expressing support for the project and others raising concerns demonstrate a healthy democratic discourse rather than failure of public participation. In light of the above submissions, the respondent humbly prays that this court finds that Salma Limited cannot be held liable for its contribution to greenhouse gas emissions in environmental disasters, that the Republic of Malindi has no responsibility under international law for the transboundary harm claimed by Samira, and that the environmental assessment process was conducted appropriately and respected the constitutional right of public participation. I seek the floor to the bench for further deliberations.
Petitioner, you have 2 minutes.
Much obliged, my lord. It is the respondent's assertion that matters regarding public participation should be held as matters of public development and clear legs, which is very wrong, because the right to public participation is enshrined under Article 10 of the Constitution of the Republic of Malindi. It is also enshrined under Article 18 of the Paris Agreement. And my lord, it is clear in the fact sheet under paragraph 17 of the compromise that Professor Bakari was required to perform public participation engagement with more than half of the population that was being affected. Therefore, they have submitted that 47% was enough, which is very wrong, because that was supposed to conduct more engagement with people, more than half of the people impacted. My lord, it is therefore, they have submitted that it was an unforeseeable event. But under paragraph 24 of the compromise, we see conflicts from non-governmental organizations prior to the flooding, which shows that although it may be an unforeseeable event, they were warned earlier before the flood started. Very much. I'd like to see the floor.
We'll have brief comments from the commissioners. They are allowed.
We can now consider the matter ended, considering we have one judge who really needs to, she's coming from far. So, we can have some small comments. I can even see the chat has congratulated all of you, although it is asking the bench to be lenient. Hopefully the bench has noted that it has been requested to be lenient from the audience. Yes, other than that, I think we can, before we get comments, I think we can get some comments from the audience. We can start with Jasmine.
Hi everyone. Hi everyone. For the council, you guys are great. You did your best, and the judges, yeah, you brilliant. That's all. Yeah.
Thank you very much, Jasmine. We can also have our good friend here, who is also a Moot, by the way, to lead the ICJ. Moot, you can give us a few comments on where so you can improve all of those things.
So hi everyone. So this session was great. I really loved everything. So I really loved everything, your performance and even the judges. So the judges were good. So thank you.
We can have some comments from the participants, considering. Yes, we can start with you.
Hello. I'd say that the process was okay, it was quite fair. The judges, I guess from the comments of the people, the judges need to be like a bit lenient, but yeah, they were fair.
Greetings. Thank you for being our judges for this session. It has been a great session, one of the best I've ever attended. And I'm pleased to be part of this. Thank you.
Greetings. This was a very educative session, and we'd like to thank our judges for being here.
Greetings. We would like to appreciate the bench for the quite informative but also educative session that they have enabled us to leave, that there's no stone that is left unturned. Thank you.
A few comments, just general comments, considering time, please. One time. Yes, please take some comments. General, brief. Be brief.
Good evening. For me, it was really impressive considering you're first timers. Even me when I was a first timer, I was not as good as you. You really did good. And what I'll tell you is mostly look at what you refer to the bench. If you're not sure what to call the bench, just say honorable members of the bench. I noticed some of you were referring to us as your excellencies. It's not supposed to be like that. Yeah, also, yeah, you did good.
So hi guys. So I was honored to present today's session, and I will exercise my Article 32 freedom of opinion to say that I think the gentlemen are outstanding for both the teams. I'm only exercising my freedom of opinion, which is very subjective. Other judges have gone, the scores are gone already. So the only thing I will say about the issue is that you have to be specific with your submissions. The authorities, be clear on the authorities you are citing. The introduction, don't bring up the issues that are not in contention. Talk about specific articles that you are alleging have been violated. That limits the scope of what you are covering, so that now I'm restrained from asking questions that really don't help on your submissions. Because I only ask things that are not in line with your submissions or what is in contention if you stretch a bit. Then again, for you, try not to read. You people have very good submissions, but this round, you can review the other team that submitted the reviews online. You see the submissions of the other voters. The reading was a bit more for this round. You have good submissions, but don't read. That counts on your marks on persuasion. Then the answering of questions. Find a way of noting whether a question is factual or legal. So that if it's a factual question, just be factual. If it's a legal question, just answer with legal backing. So if it's a legal question and you start using the facts, like the 50% requirement, that's a factual issue. Is there a legal provision that requires the same to be done? If there is no legal obligation under the same, then the facts don't really matter a lot. So just for the MCA process, please look at the specific regulation 17. Regulation 17 of the environment impact assessment and audit regulations of 203, regulation 17. That is what it stipulates what public participation in the environment social impact assessment study. That is the public participation I'm looking for. So if you frustrate and look for it in the real declaration and whatever, you are going away from what is required. It's just in the regulations. First of all, classify the project.
what project are we talking about? Is it a high-risk project? It's in the second schedule, the specific paragraph that talks about mining of lime. They have even listed the minerals that are involved in high risk mining. So if it's a high risk, a low risk, or a medium risk project, then from there now we can go to the requirement of environment social impact assessment. Because if it's not listed there, there is no requirement. So you must be very categorical on the requirements. For transboundary hub and the issue of greenhouse gas emissions, I think there is a lot of work to be done on those issues. Because for transboundary hub, I need to know the authorities, the international. We have talked about international law. Do they have an obligation at the international law? If that issue is on international law and you cite things that are domestic, now you see you are not using what I am asking. And you must know why are you using international law? Is it your Article 2, 5, or 6 of the Constitution? Is it a treaty or a general rule? Because that is the only question I asked on that issue. And if you don't know that, then everything you cited seems to have been, you don't know the reason as to why you're citing those things. So I believe those are the only two issues that are of concern. The other one on jurisdiction, you just have to go around your section 13 of the Environment and Land Court Act and your Article 162 too, because jurisdiction emanates from the Constitution or statute or both. So you're only working with the Constitution and the statute. But now you must bear in mind Section 129 on the jurisdiction of the tribunal. Because if you tell me something is within this court's jurisdiction, yet it is still within the jurisdiction of the tribunal, and the same was not approached, we have a problem with that. If the issue concerns human rights and the High Court was not approached, we still have a problem with that. So for jurisdiction, you must look at the jurisdiction of this court and the other related avenues, the tribunals and the other courts, so that you tell me this issue. If I ask you, could it have gone to the High Court? No, because of this and this. Could it have gone to the tribunal? No, because of this and this. Could we have used the other dispute resolution mechanisms? No, because of this and this. Or yes, because of this and this. So if we limit the issue of jurisdiction to Article 162 and Section 130, and you don't know the provisions of jurisdiction for the tribunal, for the High Court, for the other international courts, for alternative dispute resolution, you will still have a problem. So it's still a broad issue that requires understanding and a lot of things. So I think the session was very good. You get yourselves with the other teams that from the online thing. And now, today, the marks for today plus the cumulative of your memorials will arrange you from 1 to 4. Then team 1 goes against team 4, team 2 goes against team 3 for the knockouts tomorrow. So that you don't say there is any fixing. It's according to your performance in the memorials and the orals. For knockouts tomorrow, purely orals. And then just check out the advocates dress code. Because some things are very petty, but they will cost your marks on demeanor. Imagine you see my score sheet, the discrepancies maybe 1, 2 marks because of something very, very minor. Even the way you conduct yourselves when you are seated, you lose 1 mark because of that. The way you do your example, I have already indicated the marks. But the way you do determines whether I add a mark or I deduct from the submissions that you're doing during the mark. And for the respondents, kindly be responsive. Respond, that is the work of the respondent. If you bring out something that they did not say, then what was the essence of their submission? You should say the respondent, the petitioner said this, but it is the respondent's submission, this. Then a clarification, it's a petition, so we have petitioners and respondents, not plaintiff and defendant. Petitioners and respondents. Then for the respondents, we have the Attorney General on behalf of the government, because that case cannot reach the government. It's not a criminal case for the Republic versus an individual. So it's the Attorney General. Never has to be a respondent because there are issues of the process on public participation, and Tarnal Limited has to be a respondent. So we have 3 respondents: NEMA, Tarnal Limited, and the AG. And then the petitioners are the 3 organizations on behalf of the people. And we are understanding for those who have done it properly. For the respondents, it's basically fair hearing. You are responding to the allegations, so you should be given a fair hearing. Then the organizations, they should use Article 22 and whatever. And to 88, is it to 58? I think it's to 58. Yes, so I guess that should be it. You can reach out to the other judges, prepare for the locals tomorrow. Maybe you can, we are here because of the A&E Moot Court Society and the legal post, and our president is here, plus the coordinator of the legal post. So I think you can still hear from the president, the new Moot Court Society.
Yes, President, wait, man.
Sorry, that's very low. I highly appreciate the person who took their time to participate in this. This is our first internal intercohort competition. I want to promise everyone that they will be happening every semester at least once, and we encourage participation from every other person. I enjoyed the session. I enjoyed this. In fact, I had fun listening to your submissions. When the session started, I actually insisted, I will inform Ashley that you have to be very confident, and she has actually done what I expected in terms of confidence. And I encourage the first year to participate in our notes, because one thing that the African University Moot Court Society does is trophy hunting. We hunt trophies. Every other moots that we go in, we make sure that we take trophies from that place. So for the judges, I highly appreciate your sacrifice in your time. For the baby, the same. For the other person here, for the participants, the same. And we will work to ensure that every other law student is not only mooting, but is great in terms of oral advocacy and research. We promise that both I, as the chair of the Moot Court Society and the chair for the research, that's actually the legal post, we have to make sure that when you come up with this institution, you're fully equipped with the legal tools to face the world as a great lawyer. Thank you.
Go watch YouTube, go watch the comments. Because I swear to God, if what I'm saying is true, the margin of appreciation is very low, especially because of the memorials. So memorials, the margin of appreciation is very low. So utapata ni Austin's team is the first one, alafu Eliz's team is the second. Austin's team is the first one. You don't know. I'm telling you, the margin of appreciation is very low, because we were also reading in marking the memorials. We did not look at certain things. We closed our eyes because we also did not train you to write memorials. So the margin of appreciation is very low. There are 34s, 33s. So when you do the average plus this, like this. So prepare for knockouts, and we wish you all guys all the best. Yes. And yes, I'm a vote of thanks to your soda.
I still have an extra.
Oh yes, we still have an extra soda. Good sir. Yes.
I'm not sure.
Aye.
And